All right, we're called 26 CR 189, the state of Texas versus Corey Michael Fontenette. You're Mr. Fontenette. And you're here with Ms. Manaldi, your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment thereof? Can we proceed in summary?
Yes, sir.
In summary, sir, two paragraphs here constitute the state jail felony. In paragraph 1, this alleges that you committed the offense of theft of a value of less than $2,500. And then paragraph 2 goes on to allege that you have two or more prior theft convictions. Two or more prior theft convictions mean that even if you steal a pack of gum from here on, it's a felony. So we're looking at a state jail felony, the way it is charged, which means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, you may be assessed a fine not to exceed $10,000. Do you understand the punishment range applicable in this case, sir? I'm looking at the agreement. There's an agreement that's been reached where you would be pleading guilty under section 12.44 of the Texas Penal Code and sentenced to 1 year in the county jail. Is that your understanding of the plan?
Yes, sir.
12.44 provides that a court may punish a defendant convicted of a state jail felony by imposing the confinement permissible as punishment for a Class A misdemeanor, which is up to 1 year in the county jail. And the court must consider the gravity and circumstances of the felony committed, the history, character, and rehabilitative needs of the defendant. And the court must find that such punishment would serve the best interests of justice. So what you're looking at is the disposition of this will be a state jail conviction under this plan, but it's punished as though it were a Class A misdemeanor. And is this your understanding of the agreement? If I follow this agreement, you have no right of appeal. Do you understand?
So
How do you plead to paragraphs 1 and 2 of this theft? The thefts in paragraph 1 and the prior 4 convictions of thefts alleged in paragraph 2. Are you pleading guilty and true respectively to paragraphs 1 and 2? Are you making those pleas of guilty to paragraph 1 and true to paragraph 2 respectively voluntarily and because those allegations are true?
yes, sir.
Tell you what's marked as State's Exhibit 1. Did you sign that document? Understand it? Discuss it with your attorney, or the contents offered incorrect? State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived here. I will follow this agreement. Nothing further. I'm going to find you, sir, are pleading guilty to paragraph 1, the commission of theft, and 2, on the second paragraph, you were pleading true to the prior theft convictions. So paragraphs 1 and 2, the one theft, less than $2,500, is enhanced because of your pleas of true to two or more prior theft convictions. In paragraph 2, you pleaded to all 4 of your prior theft convictions. This constitutes a state jail felony, and the agreement is that you would be punished under section 12.44 of the Texas Penal Code as though it were a class A misdemeanor. The court finds that this decision and agreement is in the best interest of justice, as the court has reviewed your history, criminal history, your character, and rehabilitative needs of the defendant. And the court finds that punishing you for a class A misdemeanor under these circumstances would serve the best interests of justice. But once again, you would be convicted of the state jail felony. Do you understand what's happening?
Yes, sir.
All right. I hereby find you guilty beyond a reasonable doubt. In paragraph 1, the theft, and 2, I find those allegations of prior theft convictions to be true. And you have pleaded guilty voluntarily, knowingly, intelligently. And State's Exhibit 1 is made a part of the record for all purposes, and that supports your guilty plea to find you guilty beyond a reasonable doubt of this state jail felony. I so find you guilty of this state jail felony of theft in paragraphs 1 and 2. I am following this agreement based upon the Penal Code, section 12.44. That is, it is in the best interest of justice that you be found guilty of the state jail felony, but be punished as though it were a class A misdemeanor. I so find that you are convicted of this state jail felony, and you are hereby punished for confinement in the county jail for a term of 1 year. You will be given credit for all time you have served in accordance with this so far. Do you understand what's happened today? Anything else?
No.
That is all. Thank you.